apologise for the slightly late start. I hope you'll forgive us for that.
My Lords.
Mr. Holland.
My Lords and Lady, I appear with Mr. Joseph Thomas for the appellant, Mrs. Strack. My learned friend, Mr. Hugh Flanagan, appears for the respondent, Secretary of State. And my learned friend, Mr. Douglas Edwards, KC, leading Mr. Michael Rhymes, appears for the interested party, Laing Homes. The second interested party doesn't appear, Hartsmere Borough Council doesn't appear and is not represented.
And they weren't represented in the court below either?
No, they weren't, no.
Just to help you, we are of course familiar with the papers before the court. We've taken particular care to read the decision letter, as well as the skeleton arguments, of course. So we come to the case with that degree of familiarity, and I hope that our saying that now will help to save time going through things.
My Lord, I'm very grateful. If I will proceed at the pace that I was going to, if I'm going too slowly or too quickly, or if I'm mentioning things that don't need, please feel free to intervene.
We'll gently let you know. Yes.
I'm very grateful.
And then the other thing which really goes hand in hand with all of that is, have you discussed between you how you would divide the time today? We
had a brief conversation this morning. Provisionally, I would be most of the morning. I would hope to get finished by about 12:30.
Right.
And that would leave, I think, my learned friends have agreed, that would leave them enough time to make their submissions with a brief time for me to respond by 4:30 this afternoon.
Good.
We'll finish by 4:30 this afternoon.
That's fine. Well, that sounds good. We do have to finish the hearing in the day, and we would like to finish it by 4:30.
Well, again, if my Lord feels that I'm being dilatory, please feel free to I'm no doubt.
I'm sure that won't be so. But anyway, thank you very much.
I propose to start with ground one. Fair enough. And I make some preliminary points. I propose to take things very much as we do in our skeleton argument.
Yes.
I hope that will be helpful to my lords and ladies.
Very helpful, thank you.
I start with preliminary points, is this, that there is a clear distinction at law between three different legal concepts here. Oh. There is common land, town or village green, which I hopefully call TVG, and rights of common.
Yep.
They are distinct legal concepts, they have distinct legal origins and distinct legal incidents. Common land, the best definition one gets is the former definition in, I think, section 22 of the 1965 Act, which you have at divider 5 of the authorities bundle. Is it all right? I don't think the authorities bundle is paginated, but if I refer to divider numbers, is that convenient?
Yes, very convenient.
I mean, I've printed them all off in my old-fashioned way. But
well, do you want us to look at that? Unless it's necessary, we can make a note of it.
Yes. No, I don't think. I don't think I do. Common land, but it's difficult to define. But the history is set out by Lord Templeman in Hertfordshire in the Milburn case, which is at divider 30. There's 2 or 3 pages of history of common land. Again, I don't propose to take you to that. Right. It was the derivation. Originally, it was most of them were parts of the wastes of the manor, some of which were enclosed pursuant to the Enclosure Acts, and some of which were left as common land.
Yes.
But if you look at the definition, it's set out in paragraph 17 of our skeleton. In the 1965 Act. It's a divider 5. It means land subject to rights of common as defined in this Act, whether those rights are exercisable at all times or only during limited periods. B, wasteland of manor not subject to rights of common, but does not include a town or village green. Now that definition is no longer current because the 1965 Act has been, the relevant parts have been replaced, and that definition is not replaced. But the point is, the legislature there made a clear distinction between common land on one hand and town or village green on the other. And the relevant point is that by statute now, members of the public general public have rights of recreation over common land. And that was section 193, still is, of the Law of Property Act 1925 in relation to urban common land, and section 2 of CROW, which is a divider 8, Countryside and Rights of Way Act. That's common land. Rights of common are a species of profit à prendre. If there's a definition in Halsbury at paragraph 305, volume 13, which is a divider 53 of the authorities bundle. Again, I'll take that. Perhaps the best summary is Lord Justice Lewison in a case called Norbrook and Carlisle, which is at divider 42 of the authorities bundle. And a right of common is a right, along with the landowner, to take something from the landowner's land, that is crops, or a right to graze your cattle, or a right to take timber.
Yeah. Right.
And then one gets to town or village greens, TVWGs. And again, perhaps the best definition to go, if we go to divider 20 of the authorities bundle, this is the case, the Supreme Court case of Barkas.
Yeah.
And one sees there in paragraphs 53 to 57 in Lord Carnwath's speech or judgment.
Yeah.
And it's important to focus on that. That's sets out the important aspects. Yes. And if you go to say, I'd invite you either now or hereafter to read paragraphs 53 to 57. 56 has featured below. It says that case was decided by reference to events before the amendments made with the Countryside and Rights of Way Act 2000. It was unnecessary for the House to decide whether it would make any difference if the registration was attributable to use by inhabitants of a neighbourhood under the amended definition rather than a locality. It may be that in practice, once land is registered under the Act, no attempt is or can realistically be made by owners or others to distinguish between different groups of users. However, it seems clear in principle that a local link of some kind remains an essential feature both of the use and the resulting rights. Now, the penultimate sentence was quoted by the judge and is relied upon by the other side here, but they appear to have omitted the last sentence. And the point is this, that a TVG is a distinct right. It is a right to recreate over land owned by someone else, but that right accrues only to inhabitants of a defined geographical area. And one sees that by looking at section 15 of...
Recreate is an intransitive verb, is it?
Yeah, I'm using the word a recreator as a noun, if that's acceptable.
Yes, I'm sure it's acceptable. Does it have currency in the authorities?
I don't think it does particularly. No. I use it simply to as a shorthand for those inhabitants of the relevant defined district who have a right to recreate.
So when you say recreator...
a recreator. I'm sorry if that's...
No,
it's my own shorthand.
No, that's fine.
I hope it's not...
The shorthand's fine. It's just to be clear what it means.
Yes.
It means somebody who has the right...
The right to recreate. I'm hoping that's not doing too much damage to the English language to use that as a verb.
The English language is almost infinitely dynamic, isn't it? We can change it as we go.
Yeah, well, I hope I'm not doing. I'm not being too dynamic.
But anyway, somebody who has the right to recreate.
Right, within on the town or village green.
Yeah. Yeah. Right.
And one sees that in section 15, which is at divider 1 of the authorities bundle. And you see that in order to register a town or village green, and these are what are now known as Class C towns or village greens, that is new ones arising since 1965, applies where to a significant number of the inhabitants of any locality or of a neighbourhood within a locality have indulged as of right in lawful sports and pastimes on the land for a period of at least 20 years. And that phrase appears in 2A, 3A, and 4A. And for present purposes, it doesn't matter which.
Mr. Holland, can I just ask you this? The Act refers to inhabitants.
Yes.
Presumably inhabitants could include all sorts of people who live in the area, including children, for example.
Yes.
So they don't necessarily have to be people who have any ownership. Is that right? In neighbouring land?
I'm moving on very quickly to say, we would say it is a right of property because...
No, I know you say that.
Yes.
But does the inhabitant...
No, it would apply to anyone who owns property, anyone who tenants property, and anyone who occupies property on a more than ephemeral basis. So it would apply to, if I owned a house within the relevant locality, I could let it to a tenant, and the tenant would be an inhabitant, and as would the tenant's children. And I'm very shortly coming to the case of Fitch and Rawlings, which deals in a way with that, despite its ancient origin. But yes, but it's a right. For example, if I buy a house within the defined locality, I become an inhabitant, as do my family. If I then sell that house,
not a visitor, for example.
Not a visitor, no, technically.
So inhabitant, to my mind at least, the word inhabitant has the flavour of somebody who lives somewhere.
Yes.
That's what it means.
Yes, that's right. Someone with a permanent, someone who lives, yes, exactly. Not a mere visitor and not someone who happens to be in the district.
Right. But what speaking for myself only, what I'm at the moment not fully familiar with, and you are, is...
You say that.
Is how it then... how it's to be regarded as a property right, because you say, and I understand this is not in dispute, maybe, I don't know, but you say it is a property right, and therefore runs with the land.
Yes.
So that's the conceptual shift which I'm having a little bit of difficulty with at the moment, because the Act refers to inhabitants.
Yes.
But you're saying that the right then attaches to a particular piece of property. Is that right?
Yes, you have to live within the defined area. If you move into the defined area, you become an inhabitant. If 5 years later you sell your house and move away from the area, you cease to be an inhabitant, therefore you cease to be a recreator. So you can't, it's not a permanent right that you get once I'm an inhabitant of this particular area.
I appreciate that, but often one is familiar with the concept that there are certain rights which attach to property. They are property rights, so they run with the land.
Yes.
So they're not personal rights. They're not, they're not vested in any particular person.
Yes.
They run with the land.
Yes.
They may not consist of ownership, either legal or beneficial, but nevertheless they are rights in property. And obviously the land register frequently shows those property interests, or property rights rather. I think you mentioned profits are prendre.
Yes.
That's a property, right?
Well, that may, you can have a profit or prendre in gross. I think same as where you can have a right in common in gross, and that's the point that doesn't attach to property. Well, let me do a parallel for example, an easement, a right of way.
Yes.
If I have a right of way, that's a clear property right because it attaches to a particular property, the dominant tenement, and it's over the servient tenement. Now, that right of way allows not only the property owner to access the house, but allows the property owner's family to access the house and allows the property owner's visitors to access the house. So it's similar in that way. Or if, for example, the property owner lets the property to a tenant for 6 months, a year, that tenant has a right generally to use the right of way. So it's a property right in that way, in that it's not a right in gross. It doesn't attach to a person, it attaches to a property in the sense that in order to benefit from that right, you have to occupy a property as an inhabitant within a defined area.
But would this kind of right appear on the land register?
Well, there's a separate register that's the whole point of town and village greens. No, it wouldn't, because it's a right which it attaches to. I don't think it does. I don't think there is. There's a separate register of town and village greens under the Act, which we'll come to. But I don't think it separately attaches to a property such that you register this property benefits from town or village green rights.
Is it worth just looking at the register here?
Yes, it is.
Sorry, I don't want to cut across.
No. Well, I was going to look at the sections which set up.
Sure, yes. But then if we come back and look at what was actually registered here,
yes,
I think that would be useful. Yeah, but you take your own course with the statute, yes.
But so my point is, it's a property right because you have to be an inhabitant in a property within an area, and there's a parallel, we would say, with things like easements, which allow not only the owner of the property, but anyone living in the property or anyone visiting that person's property or any member of the family licensed to use that. So there's to say it's a property right doesn't necessarily mean you can only use it if you actually own the freehold of a property.
Now that I understand,
Yeah.
but please correct me if I've forgotten. But I think easements do appear.
Yes, they
on
do.
the land register.
Yes, they do. Oh, yes. You have to. Now they have to be registered. Section since the 2002 Act, any legal easement has to be registered. But it's a different system of registration. Except it's not. It's not an exact parallel. But for present purposes, I would submit it's a property right, in the same way as an easement is, because it attaches to the ownership or occupation of property and is not in gross. It's not a personal right that you can take with you whether you move around the country.
Can I just ask a follow-up on this? Is it right or not right to characterise it as a property right enjoyed by certain members of the public? That is to say, those members of the public who own properties within the defined area.
Yes, own or occupy, I think I would have to say. Yes.
Forgive me, own or occupy.
Yes.
But so it would be right to characterise it in that way.
Yes, I mean, I suppose if you pick your typical village green, which of course we're now told is not typical, but if you had a house round a village green, you would be advertising that for sale. Say, well, you have this is a village green. You have a recreation rights over it. It's not registered to a particular property, but it's registered in the register of TVGs.
Yes, but it is a right of property, as you've described it, or a property right, attaching to particular properties and enjoyed by that section of the public who have rights of ownership or occupation in those properties within the defined area.
Yes, I mean, it must be, I'm make it clear that I've taken you to section 15, which is what you need to show to register a TVG, and it's inhabitants of any locality or of any neighbourhood within a locality.
Yes.
So insofar as that designates those people as either owners or occupiers of property within the neighbourhood, I say it's a property right.
Yeah. What would be useful, not necessarily with extensive reference, but simply to isolate salient passages in the authorities, to have, if you like, the authoritative voice of the highest courts on what is this right, what characterises it as a right of property. We've got reference to.
It's Barkus at paragraph 53 to 57.
Wait a minute, but you're going to give us a list of.
Yeah.
Barkus at
53 to 57.
Yeah.
That's divider 20.
Yeah.
I also reference to the Oxfordshire case.
Is this the trap grounds case?
That's right.
Yeah.
That's paragraph 4 to 11 at divider 18. There's also a perhaps more detailed consideration of the history in the Court of Appeal in that case by Lord Justice Carnwath, as he then was, paragraphs 31 to 33, and that's divider 36 of your bundles.
Paragraphs
31 to 33.
Yep.
And indeed, there's another judgment of Mr. Justice Carnwath, as he then was in the Steed case at divider 31, page 476. I mean, it's characterised, if you go to an earlier case, if you go to divider 26, it's the case of Hamerton and Honey.
Yep. That's in the second volume.
That's in the second. I have that in my second volume. It's divider 26. I don't know how, if you've got the same volumes as mine.
The second volume for me starts at 24.
Yes, as do mine.
Right, Hamerton and Honey, yes.
And of course, this is derived from custom. It was, but it's the judgment of the Master of the Rolls, or Jessel.
I noticed that the leader was Fry and the junior was Fisher.
Yes.
In that case. Where are you reading from?
I'm just about to read from the beginning of the Master of the Rolls judgment, which is the top of the second column.
So George Jessel.
Yes. First thing I have to consider is what is the law of the case. As I understand it is this: there are certain rights which may be claimed by custom as distinct from prescription. What is called a right of recreation, amusement, of air and exercise, or of playing of all manner of lawful games and pastimes, is a right in the nature of an easement, which may be so well claimed by custom. Now, what is a custom? A custom, as I understand, is local common law. It's common law because it's not statute law. It's a local law because it's the law of a particular place, as distinguished from the general common law. Now, that's how it was described by the judge. But then, of course, that sort of gets overtaken by the 1965 Act, which...
what about more recent cases? Which include, there were two judgments, I think, to which Mr. Edwards had referred in his skeleton argument. Well, there's Lord Sales and Lord Burrows in TW Logistics.
I hope you wouldn't come to that, but...
Well, if you remember the case.
Yes.
Paragraph 65. This is quoted by Mr. Edwards.
Yes,
paragraph 8 of his skeleton. And then there's also reference to Lady Rose's judgment in Day in Shropshire.
Yes. Well, dealing with the TWL case, if I must, there was no issue there as to the identity of the recreators or the definitive nature of the relevant locality. That had been found by the inspector, and there was no challenge to that. The issue in the TW Logistics case was the nature of the activities of the landowner on the land during the 20-year period. And what was that? Because the landowner, the facts were that it was part of a working port, and the landowner was driving HGV lorries across it Monday to Friday once every couple of minutes. And the argument was that by reason of that, the behaviour of the recreators or the potential recreators could not have had the necessary characteristics as to constitute as of right. And it was also said that by reason of the fact that after registration, the landlord's activities would potentially be criminalised by Victorian statutes, that therefore you couldn't register it as a town and village green. There was no issue in that case as to the ambit of the recreators or who was entitled. And therefore, when Lord Sales and Lord Burrows use the word the public, they're not attempting in any way to expand the ambit of TVG rights. They're simply using it as shorthand for what I've called the recreators.
Yeah, I mean, it was that reference to the public that led me to my question just now. Section of the public.
Yes, yes.
because, I mean, I don't know whether this gets us anywhere close to the issues in the present case, but it may be undisputed that this is certainly a right of property or a property right with the description that you've given, but that it belongs to or is enjoyed by a particular section of the public, that's to say the residents or inhabitants, or what the right word is, of those properties within the defined area for the time being.
Yes. Yeah, that's key.
So it can be, we must be careful not to get, not to misconstrue what is meant by references to the public acquiring a general right to use it as such. And the public must use their recreational rights in a reasonable manner. And then Lady Rose in Day, the exercise of public rights in village and town greens.
Yes.
Those statements are compatible with.
Yeah.
You would say they're compatible with the status of the right as,
yes.
as a property.
They're not attempted. It's key, as all the authorities who have focused on it have made clear, that it's not a right enjoyed by the general public.
Right.
And indeed, Section 15 of the 2006 Act makes that clear. It's not a right, it's not like a highway where you register it by showing that members of the public have used it for a certain period. It's deemed dedication. This is, you have to show that residents of a particular, inhabitants of a particular defined locality or neighbourhood within a locality have used it. I mean, if you look at the TW Logistics case, if you go to paragraph 23...
this was which town?
23.
23, sorry.
23.
Yep. And paragraph...
and paragraph 23.
Yeah.
On 18th August 2010, Mr Tucker applied to the council to register a large part of Allen's Quay as a TVG pursuant to section 15.3 of the Commons. The application stated the local inhabitants had used Allen's Quay for lawful sports and pastimes as a right for 20 years up to 17th September. So that's reciting to the local inhabitants. And if 25, the inspector's report dated 28 October 2013. He found the criteria in section 15 of the Commons Act had been satisfied in relation to that part of Allen's Quay which comprised the land, and recommended the land should be registered TVG. Inspector found the land had been used as of right for lawful sports passed by significant numbers of local people. So that's just a description of section 15.3, and thereafter, when Lord Burrows and Lord Sales use the word the public, it's shorthand for the inhabitants of the local district, because they can't. It would be a huge change in the nature of TVGs to say, oh, suddenly the public have general rights. And the key is the locality. Can I direct you? And technically, and it's not just technically, any person using a TVG for recreation or otherwise, who is not one of the recreators, i.e. is not an inhabitant of the local district, is a trespasser. And that's clear from as long ago as Fitch and Rawlings, which is at divider 12.
Yeah.
It is in 1795. It's worthwhile looking at the facts of that. It's Fitch against Rawling, Fitch and Chatteris. So there's three defendants.
Is that one of the cricket cases?
That is, yes.
One of the...
A certain game called cricket is referred to in the report.
Yes, well, cricket was quite young then.
Well, that's as Lord Hoffman points out in the passage on it, for years it was illegal.
Cricket was illegal.
Cricket was illegal. I said it's pointed out, I think, in the Oxfordshire case. And since it was difficult, he said, to see how you could have a custom of time immemorial playing a game that was until relatively recently illegal, but nevertheless it was. But it was an action of trespass.
Do you want us to look at Fitch and Rawlings?
Yes, simply this. The point is this: there were three defendants: Fitch, Rawling, and Chatteris. Chatteris proved that there was a custom to recreate over the relevant land for the local people. He was a recreant, he was an inhabitant of the locality, and he was found not liable. The other two were simply visitors, and they were found liable.
They were trespassers.
That's right.
And the judgment says that, doesn't
That's right, yes. Custom for all inhabitants, if you look at the head note,
it?
and then it's below that, this is an action trespass for breaking and entering the plaintiff's close at Steeple Bumps in Essex, and playing there with divers and other persons to the plaintiff unknown, at a certain game called cricket and other games, sports and pastimes. Please, first, not guilty by all defendants. Second, by chatteris. There is now, and has for time whereof, hath been a certain ancient and laudable custom used and approved, even the said parish, that is to say that all the inhabitants for the time being of the parish aforesaid have during all the time aforesaid used and have been accustomed to have a right, ought to have had, still a right, ought to have the liberty and privilege of exercising, playing all kinds of lawful games, sports, pastimes, in upon the close, and which and every year, at all seasonable times of the year, in their free will and pleasure. He then averred that at several times when he was an inhabitant of the said parish, and at those times being reseasonable times, he entered the logs to play cricket. The third plea by Rolling and Fitch stated and custom to be for all persons for the time being in the said parish, to the liberty and privilege of exercising, playing at all kinds of games, sports, pastimes, in upon the locus in all seasonable times. So they were different, Fitch and Rolling. And if you then go to the judgment of Mr. Justice Buller, which is at page 616, some nice and critical objections have been made to the pleadings in this case, which I first consider. It said that the plea of the defendant Chatteris does not answer the complaint laid in declaration, which is that all the defendants, together with divers other persons unknown to the plaintiff, played at cricket in the plaintiff's close, but that the plea alleges the custom to be for the inhabitants of the parish to play cricket there, and that Chatteris is an inhabitant so played, that is, says my brother Haywood, that he played there with other persons who were not inhabitants, who were therefore trespassers, and that he himself, by aiding men in their trespass, was guilty of abuse of licence and law, and therefore trespass ab initio. This objection, supposed to be a good one, does not arise in the face of the plea, and if the plaintiff would have availed himself of it, he ought to have set it away by replication. It cannot prevail on a motion in the rest of judgment for admitting to have more weight than I think it has after verdict is cured the status of due. And then, can I ask you to look at the paragraph beginning, but the real question, down to the end, just over the page.
And over the page?
Yes, yes. So,
Right.
and you see there must be judgment for the custom alleged by Chatteris, the custom of the locality, was a good one, and he got off, and the other two defendants who said anyone who's in the district can play was a bad one, and they were found liable.
Right.
And that's the point. Now, what has been said is worthwhile dealing with it now, because it impacts upon the definition of interests of the neighbourhood. What is said by isolating that sentence we've read from the judgment of Lord Carnwath in the Barkas case is that, oh, well, it recognises a matter of practicality. The people who are not technically recreators can go on a town or village green and no landowner is going to stop them. Well, that's not right, we would submit. One, they are technically trespassers. And Parliament has, as we've seen, constantly maintained the difference in law between common land and town and village greens, and has not, unlike common land, accorded rights of recreation to the general public over a town or village green. And it's not simply right to say that, oh, there's an implied licence because the landowner tolerates the actions of members of the public who are not recreators, because that would undermine the entirety of the law of prescription, which in fact applies to section 15. Can I ask you to go back to the Barkas case, which is at divider 20.
Yeah.
And ask you to go to paragraphs 17 and 18. And this is Lord Neuberger. Because the difference between acquiescence and tolerance on the one hand, and permission, express or implied, on the other, is absolutely key when it comes to the law of prescription, which, by reason of statute, applies when you're dealing with acquisition of title village greens. And the point is that you can't simply say, wave a magic wand and say, oh, well, the interests of the neighbourhood here must include the ability of people who are not recreators, using it in that way, to access the TVG land because there's an implied licence of the landowner. That doesn't work. There is no implied licence because there's a key difference in the law of prescription between acquiescence and toleration on the one hand, from which you can derive a prescriptive right, and permission, express or implied, on the other, which would negate any prescriptive right. And there's all sorts of arguments one looks at in the various cases in the House of Lords Supreme Court as to whether a landowner has impliedly consented to people using its land, their land. Because, as I say, the key difference is a prescriptive right has to be nec vi, nec clam, nec precario, not by force, not openly, and without permission. And if it was the case that simply by tolerating non-recreators on a TVG, that was to be an implied permission, it would, in my submission, fatally undermine the law of prescription in this case.
Mr. Holland, can I forgive me for interrupting?
Yes, no.
Can I suggest that there's an air of unreality about this? Because let's say that I invite some guests to come and have Sunday lunch with me and I am an inhabitant.
Yes.
And after lunch we decide to go for a walk on the village green and maybe watch a game of cricket. Are you saying that I'm not a trespasser but my guests are?
I would submit technically yes.
Even in that situation, they don't have an implied licence.
Well, there's no authority which says that a licensee of an inhabitant recreating on a TVG is not a trespasser. I mean, as a matter of reality, I accept that a landowner who is subject to TVG rights is not realistically going to police the recreators and say, right, you live in the district, you're just his mate, so you can't come on. But technically, I would say yes, there is a difference. I mean, but it's a different thing we would say from saying, I mean, that's not the interests of the neighbourhood, which is the key here. Mm. You see, because the licensee who comes on to watch the cricket is there with the express or implied permission of the recreator. Mm. Hi, look, there's a cricket match on the village green. Come and watch, have a picnic, have a beer, out and watch the cricket. But it's quite a different thing to say that not only the recreators can do that, but someone who simply lives nearby in what might loosely be described as the neighbour who's not a recreator can come on automatically. Technically, they're trespassers. And technically, the landowner would be able to seek injunctive relief against them. We've had recent authority from the Supreme Court as to injunctions against persons unknown. But, for example, if on the replacement land or the release land, Laing Homes were to say, well, hold on, there's a whole load of people using this land who are not inhabitants of the relevant district, they would be entitled to seek injunctive relief against those people, against persons unknown. Say, sorry, you don't live there, you have no rights on our land. This is our land, And we're only subject to the rights, the TVG rights of the recreators. It's private land otherwise. So the point is that it's key, we would say, to a TVG that the rights are limited to the inhabitants of the relevant locality. And I think we've made the point, and we say it's a property right. We discussed that, and there are authorities which show that courts should be astute to safeguard property rights. Now, yes, you might say, well, hold on, the exercise under Section 6 is not completely abrogating the recreator's property rights, it's altering them, because you're removing your rights from the release land and replacing them with rights over the replacement land. But nevertheless, it's altering those rights, potentially without the consent of the recreator. So it is an interference with a property right. It's like saying, well, you live in that house there, I know you like it, but we're compulsorily purchasing that and giving you this house here, which is very nearby, we think you like it, but it doesn't matter, you're going there whether you like it or not. So it's a property right, and this is an interference, albeit not a complete abrogation of that property right. And courts should be astute to, and have been astute to, ensure that property rights are properly protected. And we've cited some authorities. I have to get a Northern Ireland case in, there's that Landlords Association.
But they are properly protected, aren't they? Because you have to go through the various statutory criteria in Section 16. You have the inspector's decision. So there's an independent person who comes along and balances the various rights and interests concerned. At the moment, subject to anything that's said in response, I can understand your submission that there's an interference with property rights. Where I have difficulty is understanding the submission that there's something improper going on.
Well, no, I mean, the point I think we make in our skeleton is that courts be astute to ensure that the statutory process is properly followed, and that the hoops that the statute sets out, or the barriers, are properly jumped through or jumped over. I think that's what I'd say to that.
I mean, that really is the heart of your ground one, isn't it? The point you just made.
Courts
have been astute. Sorry.
So no. It underpins ground one, but yes, I would accept it underpins that, and we would say there's not a proper. You have properly then to consider what Parliament means in this context by the interests of the neighbourhood. Yeah. Another preliminary point I was going to make, but I think I've probably already made, is that Parliament has constantly separated TVGs from common land. There's a Section 15 of the Act, Section 38 and 39 of the 2006 Act apply only to lands of common, and as we see in Sections 1, 2 and 3 of the Act, there are separate registers maintained for those interests. So Parliament has recognised that they are separate rights, or separate legal concepts, and has maintained that, having legislated, I think, 3 times at least in this regard. 65 Act, amended by the 2000 Act, now the 2006 Act, Parliament has kept them separate. We spent a little time in our skeleton then looking at the origin of the word neighbourhood in Section 16(6)(b). It's clear that Section 16 was intended to replace and update what had been Section 147 of the Enclosure Act 1845. Again, we've got that in the bundle, it's divider 2. But that made no mention of neighbourhood at all. Where we first see neighbourhood, it's in relation to common land in the Commons Act 1876, which we see at divider 3. And there's various mention of the benefit, if one looks, again, divider 3, and in the preamble, about just below the second hole punch, you see the passage, if made on the terms and conditions of the provision order, would be expedient having regard to the benefit of the neighbourhood as well. And this applies only to common land. Well, then it goes to section 7 of that act. In any provisional order in relation to common, the enclosure common commissioners shall, in considering the expediency of the application, take into consideration the question of whether such application be for the benefit of the neighbourhood. At that stage, there was no general public right of access to common land. And again, section 7.5, any other specified things to be done which sought equitable expedient regard having had to the benefit of the neighbourhood. And one sees also reference again in section 10.3 and 4 and 5 and 6. Indeed, if you look at sections 10.5 and 6, they appear to contrast the benefit of the neighbourhood with private interests. You see the reference to private interest in the second sentence of subsection 5, and then they're contrasted in the last bit of subsection 6. And that was to do with the enclosures of common land. And it's tolerably clear what was meant by the benefit of the neighbourhood in that context. There's no reference to neighbourhood in relation to TVGs until we get to the Crow in 2000, Countryside Rights of Way Act in 2000, which, if it goes to divider 5, effected an amendment to section 22 of the Commons Registration Act 1965. And that added the words after the inhabitants of any locality or of any neighbourhood within a locality to the definition of town or village green.
Forgive me, I'm being slow. Where are you reading from?
I'm reading from section 22.
Yeah.
The definition of town or village green. It's my fault. In B, section 22.1b and 22.1a.
22.1a and b.
Yeah. And so the reference was added there to widen the ambit of the geographical areas which might benefit from a TVG. A nice summary, actually, if you look at my learned friend Mr. Edwards's skeleton argument, that's paragraph 10, he summarises the effect and intention behind it, and I agree with that. It was felt that the word locality had been narrowly defined to be a legal or legally recognised locality, and it was felt that that was too narrow a definition, and that neighbourhood would be a more amorphous concept and would allow different geographical areas to be, or more, it would be more flexibility out of the geographic area.
Lord Hoffman described it as deliberate ambiguity or something like that.
It's an amorphous or it's a protean concept.
Protean, yeah.
Is the word.
Protean in a good sense.
Yes, but the point is this: although it is protean or vague or deliberately ambiguous in a way, when it comes to registration under Section 15, it has to be definite. That's the point. You have to have a definite area. You have to point to it can be a locality or a specific neighbourhood within it, but it has to be a specifically defined geographical area. So there's no ambiguity when one gets to registration. It's simply that anyone applying is allowed to say, well, actually, this neighbourhood, this defined neighbourhood, this number of streets, and it can be defined by looking at the number of streets, or indeed down to the number of houses in the number of streets.
So the concept as a whole is protean,
Yes.
but in its application to particular circumstances, it must result in a precisely defined geographical area.
Exactly. And then one gets to section 16.6, and it's not entirely clear from any of the materials we would submit what Parliament intended by reference to that phrase in section 16.6b.
It must have intended something.
Well, the derivation in it's clear what neighbourhood. I mean, what looks, if one goes to it, it's clear that it looks at section 15, divider 1.
Yeah.
It's clear what there's a locality or any neighbourhood within a locality. Those are the words in section 15.
Yeah.
And that applies solely to town and village greens.
Well, the legislative history of this you've described, I think.
Yes.
That was introduced.
It says 2000. The words "any neighbourhood within the locality" was introduced in 2000.
That's right. Yeah.
To expand the ambit of the geographical areas which could benefit.
And at that stage, and indeed subsequently, Parliament has not amended or changed the concepts that are inherent in section 16.
No, well, section 16 remains. I mean, one goes to section 39.
Yeah.
Section 38 and 39. Now, those relate to the prohibition of works on common land. So they apply only to common land.
Yeah.
And if one looks at 39.1, one sees the identical set of interests as are set out in section 16.6.
Yeah.
And one can suppose that the interests of the neighbourhood, one can see how that's derived in relation to common land from the 1876 Act. But then one goes to section 16.6. Now, section 16 applies to both TVGs and common land.
Yeah.
And one goes to section 16.6, and there are 4 matters to which the Secretary of State or the inspector shall have regard. A is the interests of persons having rights in relation to or occupying the released land, and particular persons exercising rights over it. Now, we would submit.
Yeah.
Sorry.
No. Go on.
That is the rights, that would encompass the rights of the recreators, because they are persons having rights in relation to TVG land.
Just a second, sorry. That would encompass the rights of property.
Yes, the TV, yeah, anyone would say that, because that's a right in relation to, in respect of a TVG, the interests of the recreators, they have rights over the TVG. They have rights in relation to.
So, sorry, I don't want to leap ahead too much, but in a sense it helps me anyway to bring the circumstances that we're ultimately considering here into the focus of these particular sections. do you say then, among other things, no doubt, that an inspector doing their job under section 16.6 would need to consider, or should normally be expected to consider, those rights of property, the rights of the recreators, under a heading that corresponds to section 16.6a?
I would.
Sorry if that's rather a ponderous way of asking.
No.
The question.
Well, I mean, I want to deal with C, D, and then B, if I may.
Of course,
Way. But C is the public interest, and again, that's a comprehensible head, and indeed one has further definition of that set out in subsection 8. Read subsection C to the public interest includes public interest in nature conservation, conservation of the landscape, protection of public rights of access, the protection of archaeological remains and features of historic interest. So you're directing the public interest, which includes those specified matters. And D is a catch-all, any other matter considered to be relevant.
Yeah.
And then one gets back to B, the interests of the neighbourhood. Now, my primary submission is that that cannot be a reference to the rights of the recreators, because it would be very strange indeed if Parliament in the previous section had referred to the right of the inhabitants of any locality or of a neighbourhood within a locality, and then intending to refer to the rights of the recreators had used the words the interests of the neighbourhood in section 16.6b, the very next section. I mean, as a desperate last bat, I might say, well, that's what they meant, but it doesn't appear that way. It's not a reading of you. It's difficult to read the interests of the neighbourhood as the interests of the persons in the locality or of any neighbourhood within the locality. So we submit that that's not what they're getting at here.
Well, can we just pause on that point? I suppose the question would be, why not?
Well, it would make sense, I suppose, if there was a separate heading, that if it's not in A, then to make it clear it's the rights of the recreators. I'll use that in B, but and that would then apply to it would clearly have reference to and be clearly comprehensible in relation to TVG. It might be difficult to deal with it in relation to common land. How would the neighbours that? But you may then say, well, if an application is made under section 16 re common land, well, you ignore section 16.6b because it clearly only relates to TVGs. But I think the point is this: in the previous section.
I'm just looking at that,
Yeah, the Parliament has clearly used, you can register, what is the inhabitants of any locality or of a neighbourhood within a locality. Now, clear words, why, if Parliament was intending to mean that, would they use the word neighbourhood solely without using locality or neighbourhood within the locality?
Well, the answer might be because Parliament was intending to engage a broader concept than merely any neighbourhood within a locality in using the word neighbourhood in 16.6b, and that was deliberate because it wanted to encompass that broader set of interests in the deregistration provisions. And that would be an answer.
Yes, but the problem with TVGs is how do you fit that in? Because if it means the interest of the recreators, those that have actual rights over the release land and are to have actual rights over the replacement land, are naturally dealt with in section 16.6a. they are people who have rights in relation to. You could easily say, well, that must include the recreators.
Well, look,
The interests of...
is there another way of looking at this altogether? Clearly, those interests of the recreators need to be focused on somewhere in this whole
Yes.
process. It might be asserted, whether soundly or not is for discussion perhaps, it might be asserted that provided those interests are properly heeded and taken into account in the deregistration process, then, as it were, all's well that ends well. It's been done.
Yes.
May not have been done quite where it ought to have been done, under the heading under which it ought to have been done. But provided it is done, it is done.
Yes.
Imperfectly, but effectively, lawfully. Now, maybe that, I don't know whether that's an attractive proposition or not, but if it would follow, it might follow that if, or it might precede that if 16.6b can be given that broader meaning, which is, as it were, deliberately beyond section 15 to whatever it is, then that can work. And for all practical purposes, the decision can be lawfully made in the way that would allow.
My Lord, I accept that. Obviously, the rights of the recreators have to be taken into account, and we would say have to be given great weight in the exercise, in the exercise mandate or the consideration under section 16.6. I mean, point we are making, get to it now, is this, that whatever section 16.6a or section 16.6b means, Parliament cannot have intended the decision maker to balance the rights of the recreators who have rights to go on the release land and will have rights on replacement land against or with the prospect of access to the release land by people who are not the recreators who might live in the locality. And I've used locality in a non-technical sense there. And that's what this inspector did.
Well, where do you derive that proposition from in the statutory language? Because when I read subsection 6, it simply requires the appropriate national authority to have regard to each and all of paragraphs A, B, C and D. And then isn't it a question of balance for the relevant decision maker?
Well, neighbourhood is a protean concept. It can mean the people living in the neighbourhood. It can mean the built environment of the neighbourhood. It can mean the ecology of the neighbourhood. It can mean the reputation of the neighbourhood.
All of that I understand,
Yeah.
but you said a moment ago, and I can't remember verbatim what you said, but you said you attributed an intention to Parliament. Parliament cannot have intended that people who have rights, recreators who have rights in relation to the released land, should ... I'm not sure what...
Well, the point is this. What the inspector's done and the judge has approved is said, well, look, the recreators, this land, the replacement land will be further away from the recreators. Therefore, that disadvantages them. But it will be nearer to those who are not recreators. That's an irrelevant consideration because those who are not recreators will have no rights over the replacement land at all. They will be trespassers. That's the point. Now, whatever neighbourhood means in relation to TVG, it cannot mean the prospect of access by people who will be trespassers.
Forgive me, why is it irrelevant in the statutory scheme where a very wide range of matters need to be taken into account by the decision maker, including, but not confined to the interest of the neighbourhood, it also includes any other matter considered to be relevant?
Depends what meaning you give to neighbourhood in this concept, or in this context. It might mean something different when one's dealing with replacement common land, But here one's dealing with a TVG, which is a separate legal concept, as I saw perhaps at too great length to identify.
On deregistration, when there is replacement land, as in this case,
Yes.
if the deregistration and exchange are approved, then what rights attach to the replacement land upon that process being final?
Well, that's dealt with in section 17.
Yeah.
And generally, it's exactly the same rights. That's the point. They can make. You can be. Their directions
Right,
can
so
be
it's
made.
not as if there will be, as it were, for all time because of the locality considered or neighbourhood within the locality considered at the point of registration years ago. That doesn't mean that on deregistration, parallel rights or equivalent rights will not attach to those who form the corresponding neighbourhood.
No. That's the point. As we read this, all it does is replace for the existing recreators one tract of land with another. It doesn't create new rights for those who happen to live now closer to the replacement land.
All right, but it creates at least for the original locality within neighbourhood within a locality defined will enjoy equivalent rights over the replacement land.
Yes,
And that's provided for in section.
it's section 17.
Yeah. Is it 5B?
17.5.
Yeah, 5, and particularly paragraph B. I think.
Yeah,
Yeah.
that's the
But
point.
there won't be a new set of rights created
No.
for others.
No.
But assuming you're right about that, and no new set of rights is created for anybody else, why might not the wider neighbourhood have an interest in what happens on the replacement land, which falls for consideration under this provision?
They might, but not as far as access is concerned, because they don't have any rights.
No,
They-
but it doesn't talk about access. It just says the interests of the neighbourhood, which is
Well,
a very broad
Yeah,
concept.
yeah, it may do. So I've narrowed. I'm sorry, it might make clear. I've narrowed my submission a bit much that what you cannot do is consider the prospect of access. So now, the neighbourhood may say, well, yeah, actually, the replacement land is nearer to another group of people who will have a nice view over the replacement land, or it will ensure that they maintain a nice view. Now, that might be a relevant consideration, but that's not what this inspector's done. He's balanced out the fact that on the one hand, the replacement land will be further away.
Okay, well, I've got that point,
Yeah.
but you now appear to be conceding that the interests of the neighbourhood might have a meaning which is different from the interests of the defined neighbourhood.
Yes,
Okay.
I mean, it certainly might do in relation to common land. It's difficult to, it's difficult to see, but for example, if one looks at the definition of public interest in section 6C, you might say, well, the interests of those who live in the immediate vicinity of the replacement land might be covered by the public interest. And indeed, public rights of access are specifically considered under section 6C by reason of section 8 or subsection 8. But there may be separate interests. I'm not saying it's completely meaningless in respect of TVGs, although it's difficult to see how one might fit it in when one has section 6A and section 6C. But what you can't do is simply say, well, the replacement land is nearer to another neighbourhood and they can use it because they will have no rights to use it.
But is it your submission may or may not sit with the following question and answer, and the question is, do you accept that the provisions of section 16(6) do not ascribe any priority to the recreator's rights?
No, there's no express hierarchy. I couldn't say that.
Or that particular weight or greater weight ought to be given to the recreator's rights?
Well, we say yes, that as a matter of common, that's where I banged on perhaps to length about the proper nature of the property rights, because it should be given particular concern, particular weight, because it is a property right, and you are effectively altering that against the will of the recreators in this case.
So,
But yes,
so
there's no express statutory hierarchy.
there's an implied priority, you're saying.
Yes.
And is there any authority that supports that proposition?
No specific authority on this particular.
Which authority would come closest to
Well,
doing so?
We simply relied on general propositions in relation to the property right. And I gave you, it's the Landlords Association of Northern Ireland case, which has it divider 35, paragraphs 40 and 41, and I think it's Lord Collins.
Well, do you want to look at that? I mean,
Yes.
because actually we may be getting close to the heart of at least
Yes.
round one here.
Okay.
And if
Well,
you
it-
can
divide-
derive support from that, then let's look at it.
Yes, divider 35.
Yeah. Yeah. Justice Gervin, I see that
Yes.
was.
Yes. And again, I don't say this is not to do with this
No.
statute, but it's paragraphs 40 and 41 where you summarise it. And it's paragraph 41.
Well, I was going to note, if I may,
Yes.
because it's one of my favourite cases in history, Entick and Carrington,
Ah,
paragraph 40.
I think it's lecture 101 of constitutional law. Certainly was in my day.
Indeed,
In my day, it was constitutional and administrative law,
Yes.
and that's no longer a
Yes.
lump
They're
together.
no longer combined.
Yes.
It's attributed to Lord Justice Pratt. I had thought, probably mistakenly, that it was Lord Camden, the Chief Justice of the Common Pleas. But in any event, the important sentence is, the great end for which men entered into society was to secure their properties.
Yes. But it's a general. I mean, it's a general assertion, and what Justice Gervin, as he then was, draws from it is paragraph 41. Now, I don't say that is a case on this. I mean, we deal with it. Or if one goes to divider 38,
Yeah.
one sees that's Sainsbury's supermarkets.
Yeah.
case.
That's Lord Collins, is it? Yeah.
That's right. That's compulsory purchase, and the bench will know volumes more about that than I do. But it's paragraphs 9 to 11 of Lord Collins' speech in that.
9 to 11.
Paragraphs 9 to 11.
Thank you. Do you want us just to look at those?
Yes,
Yeah.
they're very brief. As usual in the highest court in this country, they cite an Australian case.
Ah. That speaks of the Chief Justice French in the High Court of Australia in the Parramatta case. Protections are not absolute, but take the form of interpretive approaches where statutes are said to affect such rights. Presumption in the interpretation of statutes against an intention to interfere with vested property rights. Is that coming close to the
Yes,
focal point?
the point I make is that there's no specific hierarchy set out apart from the one in order A, B, C, D. In that, it's not said not specifically said one consideration is more important than the other, unless you say, well, A is more important than B is more important than C. But I'm not sure that's a proper reading of the statute.
There's a listing,
Yeah.
but there's no there's no explicit
No, there's not.
prioritisation.
There's not. But as a matter of law, we say if we're right and this is a property right, albeit of a slightly unusual kind, then any decision maker has to weigh that very strongly in the balance and not interfere with that. And we say, we come to ground two, that's reflected in the policy.
Yeah.
Because it says that even if you make a compelling case for a placement, you won't get it unless the interests are the exact wording of the policy would come to it. But that simply reflects, we would say, Parliament or the author of that policy is simply reflecting that.
But how much force does that presumption have in a case, in a statutory scheme, in which there's an exchange for the bit of land over which the rights are exercisable?
Well, I accept, as I expect, this isn't a complete it's not a compulsory purchase. It's not a complete abrogation of the rights, or indeed, you take your rights away and we forcibly give you some money for it. But it's an alteration, and it's simply this, that you have to, in exercising the balance, or in considering the balance, a weighty factor is the property right. You are effectively altering the property rights of the recreators. And what you cannot do is, we would submit, is balance them against the non-rights of other people.
Yeah. Well, I don't want to leap ahead, but maybe just venture slightly ahead and look at the decision letter.
Yes. I'm happy.
And you don't want anything more from Sainsbury at the moment?
No, I don't. To give him my due, this was the next thing I was going to tell you. So
oh, right, okay.
You're ahead of me, my lord, but
no. Well, I just
not as much as I might have expected.
I just wanted to follow up on one of the earlier questions
yes.
we looked at.
Look at the decision letter.
Yeah, page 251.
Yes.
Can I just ask you the question I was going to ask?
Yes.
By all means, of course, then elaborate into your submissions on this. If we look at the structure of it, which starts at 13 really, the main structure of it, he sets out the statutory requirements. He doesn't put quotation marks around them, but he faithfully replicates the provisions of section 16.6, I think, doesn't he, at 13. There's no complaint about that anyway, I don't think.
No.
And then his headings under the main heading assessment, map onto those four paragraphs within the subsection.
They do.
We've already touched on what he does in 15, actually, because one of my earlier questions was really directed at that. There he's got a very short paragraph. He deals with the released land being owned by Laing Homes. Then he says there are no registered rights of common over it.
Yes.
Then he says the public have the right to access the land for the purpose of lawful sports and pastimes. And the effect of the application, that's the present application, on the interests of the public are considered later. And he's therefore pointing forward to subsequent passages of the letter.
Yes, he is.
He then goes on, immediately after that, to the interests of the neighbourhood.
Yes.
And in the paragraphs that follow, and no doubt we'll look at some of them, there are several references to the defined neighbourhood.
Yes, there are.
Leaving aside the conflation point for the moment, though I appreciate it's important in your argument. But there are repeated references which look deliberate to the defined neighbourhood.
Yes, there are.
Yeah. Is it common ground that in referring to the defined neighbourhood, he is referring to what I call the registration neighbourhood?
Yes.
Yeah. And doing so accurately?
Yes.
Yeah. So he is. Where does the common ground end, I suppose, is the question. Is it common ground that he is therefore encompassing within this section of his letter a treatment of the rights, the recreator's rights?
Yes. Yes.
You complain that he doesn't. First of all, that's in the wrong place. It should have come under the first section.
Yes. It doesn't matter if he's properly, because I accept
Yeah.
But, I mean, my lord will know much more about this than I do. One doesn't read these in a technical way.
No, no,
One
no.
reads it in a,
No, I'm not suggesting that you are for a moment, but he doesn't do it under A. He does it, if he does it at all, under B.
Yes.
But there are two complaints, are there, really? One is that it gets mixed with
Yes.
a more generalised assessment
Yes.
under B. And the other is that he doesn't reflect what you've described as or we've described in argument as the priority or presumption,
Yes.
or whatever it is.
Yeah.
Presumption is the word in the Australian case.
Yeah. Yeah.
And he doesn't do. You say he doesn't do that, and he should have done that. And his not doing that is unlawful.
Yes. Can I take you through?
I mean, but have I?
No. Yes, you have. Yeah,
Like-
yeah, exactly. I mean, it's my submission. He clearly focuses, in certain respects, on the rights of those in the defined neighbourhood, the recreators.
Yeah.
But then he balances them away against access. If you look at this, and paragraph 15, he deals with the interested person having rights. And he says the public have the right to access land for purpose of law. Now, that's wrong as a statement of law. Now, my learned friends seek to excuse that by saying, well, it's exactly what Lord Sales and Lord Burroughs and Lady Rose have said, and therefore it can be understood, it can be understandable because he's using that as a shorthand. He must be using that as a shorthand. But it is a misstatement of law, and in this case we say it's crucial to move away from that and identify what rights you're balancing out. And then he goes on, under the interested neighbourhood, he refers to the guidance, and then he says 17, in this case the neighbourhood of the existing village green was precisely defined prior to registration. This consists of the properties in the specified streets and those. So he clearly identifies the defined neighbourhood under, and he's considering this under section 6b. 18, the village green was registered on the basis that it had been used for intimacy of the neighbourhood, and that must be a reference back to the defined neighbourhood in paragraph 17 for lawful sports, pastime, practice and noted the main use of the land of walking, including walking with dogs and children. I'll come back to 19 and 20 when I deal with ground 3, but he then goes 21. It's clear that residents of the neighbourhood greatly value the village green and have invested considerable time and effort into its maintenance and improvement over a lengthy period. So again, I would suggest that on a proper or reasonable reading of that, he's referring back to the residents of the defined neighbourhood, if that's an acceptable phrase. And then paragraph 22, the restart, he deals with the geographical situation. The restart is northernmost, lowest lying part of the existing village greens overlooked by adjacent residential. My visit was largely overgrown and difficult to access with the exception of well-trodden footpaths. I'll come back to that when I deal with ground 3. Extremely wet underfoot and footpaths muddy and slippery. Land rises to the south and reportedly other parts of the green are more intensively used. Nevertheless, the released land is closest and most accessible to a large proportion of properties in the defined neighbourhood by way of access points on Vale Avenue and Barron Avenue that would no longer be available if the application is approved. So he clearly gets the point that the release land is geographically proximate to the defined area, or it's more proximate than the replacement land. And then he goes on, the replacement land joins the western edge of the existing green, different in character to leased land and other parts of the existing green. It's a relatively flat grassed area used for grazing till recently belt of woodland. It's further away from any properties in the defined neighbourhood than the released land. However, a proposed new access point from Barnet Lane at the southwest corner of the land would make the revised village green more easily accessible from properties to the west. Now that's not the defined area. That's where he strays into saying, because...
Can you just take this a bit more slowly, if you don't mind?
Yes, of course, I'm sorry.
Because this and paragraph 27 may lie at the heart of your complaint.
I'm sorry, my lord, if I didn't. So,
I just want to be sure that I understand, because I may have misunderstood.
Yes.
Is it part of your submission that once the inspector starts making reference to the replacement land being more easily accessible from properties to the west, that he is there mistakenly thinking that people who in law are trespassers are to be equated with people whose legal rights have been interfered with?
Yes. if you go to, just to make it clear, it's exactly right. If you go to the second bundle, at page 37 of the supplemental bundle, you can see it's figure 5. And you see the defined neighbourhood is lined in blue there.
Yeah.
And the red is the site. And you'll see running along the bottom of the site is the A411. I think that's the Barnet Lane that's referred to.
Yeah.
So revised village green is, however, a proposed new access point from Barnet Lane at the southwest corner of the land would make the revised village green more easily accessible from properties to the west. That must be a reference to properties that are not within the defined neighbourhood. Can't be anything else.
What is it that says to the reader that he's giving equivalent status or weight to trespassers?
Well, because he's saying it's further away from many properties. I'm reading from paragraph 24.
Yeah.
Many properties in the defined area, i.e. it's further away from those who have rights over it. But a new access point from Barnet Lane on the southwest corner of that make the revised village green more easily accessible from the properties to the west.
Yes, well, if he's considering, the point may be this, mayn't it? If he's considering a wider thing by way of the neighbourhood than the defined neighbourhood, he's doing what section 16(6)(b), on the face of it, seems to be asking him to do, isn't he?
Well, we say, in the context of a TVG, you cannot, whatever the rights of the interests of the neighbourhood may mean, they cannot be rights of access or the ability of non-recreators to access the land. They have no such rights, they are trespassers. And that's what he's doing. That must mean, and he's doing, I'll take you to the submissions made by...
well, before you do that, can you just look at paragraph 27?
Yes, of course. I was going to take
no,
you. Yeah.
No, I may have misunderstood the submission, which is why I ask you to make it clear to us. In paragraph 27, in the middle of that paragraph, he says that on the other hand, the released land is arguably the least attractive part of the village green for many users, and the replacement land will offer the potential for a wider range of activities on the green and will make it more accessible for some people not currently resident within the previously defined neighbourhood.
Yes.
Now, of course, accessible, the word accessible can be ambiguous. It can mean physically accessible, or it can mean legally accessible. And how do you read that?
I read that as physical accessible. It was never proposed that the TVG, the replacement land, would be legally accessible to others outside the defined area. And insofar as if it was legally accessible, then it's an error because it wasn't proposed.
Well, that's why I've asked you
Yes.
to clarify. I wondered if that was the submission you're making, and perhaps it's not.
No, it's as I read that in the context of this, it's physical accessibility is intended.
Well, then what's wrong with it? If that's all that he's saying, then as my Lord puts to you, why isn't he allowed, given that Section 16(6) is not confined to the rights of people, but it does encompass wider interests?
Whatever wider interests it does encompass, it can't encompass the interests of trespassers. It might, the rights of the neighbourhood people, they might have views over it, they might, or other things, but it's very difficult, I say, to think of them. But it cannot, you cannot balance away the rights of the recreators against the prospect of trespassers.
But isn't it realistic to take those into account? Because nobody's suggesting that the replacement land should have some form of access restriction, or you have to pop a card in to show that you're a resident from the defined neighbourhood. I mean, the reality is that anyone will be able to go onto the replacement land, as presumably the reality is that anyone goes onto the released land now, or did.
Not lawfully, technically.
Yeah.
And the landowner would be entitled to say, I'm only going to allow people within the defined neighbourhood to do it, because they would be able if they wanted to put a card up and say, or have a man in a guichet to say, a booth to say, sorry, can you prove that you live in within the defined area? Otherwise, if you don't, you're not coming on.
But what evidence was there before the inspector about the steps taken, if any, by recreators at present to keep others off the land?
I don't think there were any. There was no evidence. I don't think of any steps taken by the recreators themselves. They have rights of recreation, but they've no rights to keep others off the land because the land doesn't belong to them.
Or that anyone had de facto prevented third parties, you say trespassers, maybe that's correct legally, coming onto the land.
I don't think there was any evidence. Can I take it, sir? No, there's no evidence that anyone had prevented a particular group of, save for the denial of maintenance rights, which the landowner had clearly.
There's a bit of a hint that some people who weren't strictly entitled to be on Village Green were members of the WHVGS and had been going into the activities that the WHVGS were going into. If you look at paragraph 19,
yes,
members of 300 households, predominantly within
yes,
the defined neighbourhood, who pay the £5 per annum.
But there's no evidence that they were being contemplated when the inspector considered, for example, in paragraph 24, new access point from the revised Village Green more easily accessible from properties to the west, that those were in any way within the residents who were within the WHVGS. I mean, the point was clearly made. If one looks at the submissions and the evidence on behalf of the interested party, the point was clearly made by them that the replacement land would be more easily accessible to other residents who are not within the defined area. I can give you the references if you want.
Yeah, and the submissions on both sides on that?
There were certainly the interested party, and I'll take you to the interested party submissions. If you go to 243 of the bundle 2, or the supplemental bundle.
Yeah.
And this is the written closing on behalf of the interested, of the applicant, who's the interested party. Paragraph 21, all parties inquired focused on considering 16.6b, corresponding part of paragraph 4.4 CLP 2015, on their neighbourhood identified through the process of registration of WHVG. It is, however, the case that in accessibility terms, the replacement land will bring the WHVG closer to residents to the west than is now the case. We address the positive consequence 2 in this section of our submissions. You go to paragraph 27. And 28. Moreover, Mr. Marshall explained the proposal was on the WHVG becoming much closer and more accessible to habits to the west than Elstree. As Mr. Tars explains, all levels to the west, the railway tunnel has been assessed by HBC to be deficient in terms of accessibility to various typologies of open space. Details of the assessment are included in the applicant's supporting statement. This represents significant public benefit, whether considered in respect of adjusted neighbourhood, wider public benefit, section 16C or D. This extracts evidence that in some way the interests of those who live in the west of the replacement land railway tunnel are of less relevance or importance, since those persons inhabitants of Elstree, not Boreham Wood, still to understand these residents meet the west relevant to public and the interest of these residents, public interest to which the inspector does not have regard. So the inspector was specifically invited by the interested party to say, well, you should balance against it the interests of the wider public.
What's wrong with that?
Because they don't have any rights of access to it.
Well, that may be so, but why can't he do the balancing when he's looking at the factors in, for example, paragraph C, paragraph D of section 16, subsection 6?
Whether it's done under B, C, or D, it's not a relevant consideration because there's no rights of access. It's not a public access. You can't. That's the mistake made by the interested party, and we say the inspector to assume that this is like a public park, or it's common land with there's a general right to roam over it. It's not.
Well, that's why, and I may have misunderstood you, but so please do help me. That's why I asked you about the distinction between physically accessible
Yes.
and legally accessible. Are you saying that the interested party and the inspector fell into the error of thinking that the people to the west were going to have the legal right of access to the replacement land?
They may have done. There's no submission. I'm looking at the submission there, but what they appear to have considered, whether legally or otherwise, is that they were going to have an ability or right to access the land, and that's not right. They had no legal right. Now, it might be said, oh, well, as a matter of reality, no one's keeping anywhere, but it fundamentally undermines the distinction between a TVG on the one hand and common land or a public park on the other. And that's why I started with the distinction. To assume that you can shift the TVG land to the west and say, well, although it's further away than to the rights of the people in the defined area, nevertheless, people to the west are going to be have more easy access to it, is to fundamentally misunderstand the nature of a TVG.
And you say that the inspector therefore failed to understand the legal consequence of having replacement land, which we can find in section 17, subsection 5.
Yes. Yes.
Because, and correct me if I'm wrong,
Yes.
but as I understand it, what happens legally is that the rights of the recreators in the released land are extinguished by statute. That's
Yes.
paragraph A.
Yes.
And then they attach to the replacement land. That's paragraph B.
Yes.
But you submit that is still the rights of the existing recreators
Yes.
who had the rights in the release.
Yes.
And so if you have, I'm not saying the inspector has done this,
Yes.
but if the inspector has thought that the residents to the west are now going to have the legal right of access to the replacement land, you submit, do you, that he's misunderstood
Yes.
the effects of the legislation?
Yes, I do. I would go further as well and say this, that even if he hasn't fundamentally misunderstood it, and particularly so, if he assumed that no, the rights over it would only be the rights of those in the defined area, and then took into account the possibility of access by people to the west with no rights, then that's an illegitimate consideration because, as I've said, they are trespassers and have no such right. And however unlikely it might be, the landowner, the interested party, could seek to prevent those not within the defined area accessing the replacement land. And so it's not a legitimate consideration whether under B or C or D to say, well, I know it's further away and less convenient for the recreators, but those living to the west it'll be more convenient to them to access the land when they have no such rights. So either he has, I mean, And this is why we go back to paragraph 15, you see, when he says back to public. You see, it might be that when he's referring to the public there, he genuinely meant the public at large. And if that's right, that's wrong. That's a misapprehension of the law. And it might be that that's what led him into, and that's why we go back to 15. A statement by itself, given what Lord Sales and Lord Burroughs have said in TWL, it might be said to be inoffensive in the sense that, sorry, it's an inappropriate word, it might be said to be neutral in the sense it's just a summary of right. But looked at with what he's then subsequently found, that's why we come back to say he's conflated the rights of the general public or those living in the vicinity who are not inhabitants of the defined neighbourhood with those in the defined neighbourhood. And whether that's an error of law in that he's misunderstood what will happen to the replacement land, or an error of judgment in the sense that he's balanced out, he's purported to weigh in the balance the rights of the recreators against the interests of trespassers or potential trespassers. That's wrong as well. That's an error of law as well.
Well, you say it has the balancing exercise. I think you said was not a relevant exercise.
Yeah, it's not a relevant consideration. It's whatever the. I come back to whatever the interest of the neighbourhood might mean. In a sense of a TVG, it cannot be the prospect of access to those who are not recreators.
Well, the way you put it in a pithy sentence.
It's the first time for everything.
Well, no, I'm sure that's not so. I took care to write it down anyway. You said you can't balance away the rights of the recreators against the prospects of trespassers.
Yes.
Is the proposition you spelt out. Now, sorry, I'm going to drag us back.
Yes.
To the submissions, if you don't mind, just for a second. We've looked at what was said by the interested party in submissions. Can we look at the corresponding submissions for Ms. Strack?
Yes. Those are 213.
Yeah.
Well, paragraph 3 starts, doesn't appear to be in dispute between the parties. The neighbourhood for purpose of Section 6 is the neighbourhood defined by the original registration application.
Yeah.
So, whether that accords with what I'm now submitting to you, but it's clear that that was the focus.
Right. But what I had in mind was the submissions that...
Paragraph 30 is I think, the...
Okay.
Says there will be a new access in Barnet Lane which brings town and village green margin close to the community southwest. However, that benefit, such as must be placed in its proper context. It does not serve the agreed neighbourhood, and that's a reference back to paragraph 3, which said those new homes will be in Elstree, not Bournemouth, and given the statutory weight to the interests of the neighbourhood, this benefit such should be given minimal weight.
Well, that suggests that there is a balancing exercise.
Well, it does, but it identifies clearly when we're dealing with the neighbourhood. This is on the basis of a submission, rightly or wrongly, that neighbourhood was a reference only to the defined neighbourhood.
Yeah, but if the balancing exercise was not a relevant consideration, the submission could not have been that. Could it?
And also, the benefit shouldn't be given minimal weight; it should be given none.
Yes.
Well, that's what I'm saying.
Yes, sorry.
It shouldn't, well, it's not even that. It's the weighing
The exercise
doesn't happen. The scales aren't got out at all.
Well, not in that respect.
But this is the respect you mentioned.
Yeah, well, that was the submission made to the inspector. I say it's not.
Well, was it a mistaken submission?
It's different to the submission I'm making to you, but yes, insofar as it would appear to countenance, and bear in mind it's in the context of when they say neighbourhood, it's assumed that it means defined neighbourhood. I would go further than that point made there and say it was an illegitimate consideration. it's not to be balanced at all.
Well, it does. I mean, it would be open to you to submit, I suppose, that because it was a submission that you say was actually wrong. It took the inspector away from his own understanding of his responsibilities and led him into error. But you may submit, I suppose, that if he was in error, he was in error, he was in error. However, he got there.
Yes.
But I think, in fairness, since we've looked at the other side of submissions, we're now shining a light on those from Ms. Strack.
Yes.
We really ought to have your submission on that.
Well, my primary submission is that it's not a legitimate consideration at all, and therefore, in paragraph 30, insofar as it suggests that the interests of those in to the west or elsewhere, it's not a relevant consideration, therefore it was in error. My secondary submission is that submission is right, in the sense that if it comes into the balance at all, it's to be given minimal, if any, weight. That is the prospect of those to the west having access to the replacement land.
The difficulty, Mr. Holden, may be that once, if it's the alternative submission, and once we're into the territory of giving weight, then classically that is a matter of judgment for the inspector, subject, of course, to the possibility of correction by the court on grounds of rationality. But that's not your submission.
Well, I might go as far as to say that, in the sense that insofar as properly looked at, if the inspector says, well, on the one hand, it's further away to the defined neighbourhood, but on the other, it's closer to those with no rights, that is an irrational decision, properly, when the law is properly looked at.
Well, irrationality is not the same thing as the kind of unlawfulness that we're contemplating. You're saying that the conclusion that it should be given anything other than minimal weight, or perhaps you're saying that any weight is not a decision, is not a conclusion that a rational decision maker could make.
Yeah, I suppose it pushed, I would go that far, but I don't think I have to. My submission would be I don't have to go that far.
Right. All right. Well, we have your submission. Thank you.
I'm great. I mean, I can take you to the judgment if you want. I suppose I should do that. And that's at page 107, or one of them. Sorry, looking at the wrong bundle line. In paragraphs 68. Sets out the submissions that were made to the judge. And then at paragraph 75 picks it up. Thomas suggests the last point is now advances the primary respect line, namely respect for the rights and habits by reference to the which registration occur in the position of those in the wider area, particularly those living in the West proposed neighbourhood. It's according in this aspect now turn, because I do not accept paragraph 15, the inspector conflates the rights to define neighbourhood. Clearly aware distinction those with formal right to use the village green or wider public. Paragraph 15, the inspector undertaking the power to exercise make decision in section 16, simply reflecting the reality that those strictly rights attached to local habits, perhaps once land is registered under the attempt Bristol and made distinguish between the different groups. That's Law Carnwath and Barkas. But of course, he omits the subsequent sentence, which we've looked at. I agree Mr. Thomas Lime's 15 has been carried forward to the rest of the DL, then there might have been a question of whether the inspector was in fact aware of the position. Here's the DL, however, shows emphatically not the case. On the contrary, the inspector carefully repeatedly distinguished the defined neighbourhood and the broader neighbourhood. We see from 17, 19, 22, 27. And then you go to paragraph 81. Sorry, paragraph 80, I suppose it'd be fair to the judge.
Yeah. That says less relevant. It was argued by the claimant before the inspector that the interests of those living to the west of the replacement land and the railway land were of less relevance than the interests of the inhabitants of the defined neighbourhood. This point carries over into the statement of facts and grounds. Also features as part of Mr. Thomas's skeleton argument and oral submissions, such as in paragraph 31 of the former, where it is said that there may be cases such as this where the interests of rights holders are distinct from others and may indeed take precedence. And then the cricket example. So it looks as if, does it? In the court below, unless I'm misunderstanding that, the judge was not being invited to conclude that the balancing exercise was not a relevant consideration.
Well, I presume the judge, when he says in the inspector, he's referring to that particular paragraph in the submissions that we just read.
Well, no, sorry. Well, the submissions you've just shown me are the inquiries.
They are, yes.
And this
Yes.
is the skeleton argument
Yes.
before the judge.
Yes.
Hence my question. Looks as if the same position was maintained before the judge as was maintained before the inspector. Unless I'm misreading it.
Well, my lord, forgive me a minute. What the skeleton one sees before the judge is at divider 5, it's page 116.
Yeah.
And one sees there's a number of propositions advanced. Paragraph 18.
Yeah.
It says, taking into account the heading, the plain meaning of the text and the inspector's reason, the inspector misdirected the public at large have a right to use the town village green and proceeded on that basis. And then, if you go over to the second proposition, which is paragraph 25, public at large do not have a lawful right to engage in sports past within. Others merely have at most implied permission to use the land, plain from the clear line of authority from literature.
Implied permission.
At most implied permission. I think that's a reference to what I think it is Lord Carnwath said.
Yeah, but that doesn't implied permission isn't. You say that's equated to trespass, do you?
Yeah, well, at most, you see, that's the problem with saying that what Parliament is doing here in section 16.6b is reflecting reality, that whatever the legal rights, landowners who own TVGs don't stop those who are not living in the defined area from going onto it. But that there's a difference in law between acquiescence and tolerance on the one hand and permission on the other. There's a key difference in the law of prescription. So it's at most a right. I would submit, unless there's clear acts saying that there is implied permission, that's not what it is. There's that fish and chip shop case. I think that's the where the sign was set up from outside, and there's all sorts of arguments about whether there's consent had been granted. But If the landowner sits back and does nothing, that's not implied consent. It can't be, because, as I say, that would undermine the entire law of prescription.
Right.
And
But anyway, you're submitting to us in this court
yeah,
that it is, it's an illegitimate consideration, or it's an irrelevant consideration.
yeah.
The balancing exercise between
Yes.
the rights of recreators on the one hand and others in the neighbourhood on the other.
Yes, I can take you to just the third propositions, paragraph 27 and 28.
Yeah.
And the fourth proposition is paragraphs 34 to 35, which is page 128.
Yeah.
And at paragraph 42, so I submit that I don't think there's anything there which is substantially different from what I'm submitting to this court. The point was made that it's an illegitimate consideration.
I mean, as a matter of fact, purely fact, was it submitted, as it were, starkly to the judge that these others were or would be trespassers? Was it
I'll take instructions
Yeah.
on that.
Of course.
I think that it was at most implied permission. It was left at that.
Right, so it didn't.
I did-
You can check, by all means, check that. Don't
Yes, I will check
it
over the judgment, but my learned junior who made those submissions, both written and oral,
Yeah.
sits by me.
Well, that's grateful to you both, thank you.
My lords, I'm conscious of the time,
Yes,
and
yes, of course.
I think I finished ground one. I can deal with ground two very briefly.
Yeah.
The consents policy is at the supplemental bundle, page 292.
Right.
And we say it simply reflects the submissions I've made as to the importance when you're carrying out the exercise in section 16.6, to give proper weight to the rights of the recreators. And it emphasises also that to get a replacement land for existing common land or TUGs is a relatively high hurdle, and is intended to be so. It's that second sentence. Therefore, even when an applicant makes an otherwise compelling case for an exchange, Secretary of State's expectation will be the interests, notably landowner, commoners, the wider public, will be no worse off in consequence of the exchange than without it. And that just doubles down on the point which is made in ground one, that you can't say in that context that the recreators, the inhabitants of the defined area, it'll be less convenient for them to access the replacement land, but it will be more convenient for members of the public who have no such rights.
But that says notably the landowner, commoners and the wider public. It doesn't differentiate or prioritise as between them.
No, it doesn't. But bear in mind that's dealing with it's dealing with both commons and greens.
Well, yes, it's dealing with greens as well as commons,
Yes.
one might say.
Yes.
Um,
But it can't not include.
oh no. That's step one, but step two would be, which I think is the step you're inviting us to take, would be that it recognises or reinforces a priority for recreators' rights, but it doesn't say that.
Well, it doesn't it doesn't explicitly say you should give added weight to the rights of those who have rights over TVGs. But it emphasises that they should be no worse off, and it must be right in those circumstances that one of the considerations ought to be, well, are the recreators no worse off?
Well, another reading might be that it's anybody who is a landowner, a commoner, or a member of the wider public should be no worse off in consequence, which might be said to be a more onerous test, actually.
Well, given that, I mean, it's slightly strange in the landowner, because the interest of the landowner will be contrary to the interests of, or in the TVG in this circumstances, to the interest of the recreators, because the interested party is the landowner.
Well, we can, in a sense, we could say, I don't know if this is right or not, that the landowner can look after himself in this process, because here it's initiated by the
landowner.
And it normally would be, wouldn't it?
Well, certainly so far as a TVG, yes.
Yeah.
Yes.
Initiated by the landowner, so
difficult to see who else
the landowner looks after his own interests. Commoners are those who have rights of common.
No, over common land. Yes, there are those who might have rights of common, but now the interests of the public include the general public who have a statute.
No, just seeing how these categories work.
Yes.
Because clearly they're meant to work for both commons and...
Yeah, commoners are those who have specific rights over common land.
That's what I meant.
And you have to... Yes, I'm sorry.
Well, I'm using language inexactly, probably.
Yeah. One has to go back
to what you said at the beginning.
Yeah, to realise who those are.
And then it says, and the wider public.
Yes. As a very general phrase.
But it would include those the recreators with rights, wouldn't it? Otherwise, where are they included?
Well, they're not specifically included.
So they'd have to be in the wider public, wouldn't they?
They would be.
Unless they're excluded, which they can't be.
It's absurd to exclude them.
Yeah. So in this categorisation, they must be within the concept of the wider public.
They must be, I suppose, yes.
Yeah. So I just wonder where that leaves your argument on ground two.
Well, I'm going to leave it there, but we say because it reinforces ground one, and the policy means what it says.
Right.
Change without having interests. I mean, no worse off. And then it goes on. Our expectation more likely to be as whether replacement land is at least equal in area to lease land and equally advantageous to the interests, and that must go back to the previous sentence.
Yeah. Okay.
And the policy was dealt with very briefly in a footnote by the inspector, but it was specifically raised by the interested party, if you want. It's paragraph 6 of their submissions at page 240 of the supplemental. I'm a little behind, I'm afraid, my lords. I'm going to turn to ground 3 unless there's anything specific you want me.
No, that's fine.
Questions on ground 2 because I'm conscious that.
Don't worry. We've asked you, in the nature of things, we've asked you a lot of questions as we've gone along. I just wanted to, while we're just looking at page, I just turned up page 240.
Yes, of the supplemental bundle. Yes.
And it's paragraph 6.
Yes, paragraph.
Yeah.
Paragraph 6. Yes.
Okay. Well, we can read that. Yeah.
Ground 3.
Yeah.
Well, it's described as it's the fallback position. I'm not a planner, and I'm difficult to see how it gets dignified with a specific title. But
no, I mean a fallback. My experience of planning is a very particular thing. It has infinitely various circumstances, perhaps, but it's something that the developer can do or bring about if permission isn't granted for the development he's proposing, and it's used therefore if it's a realistic fallback, something he can do. Otherwise, it's used as its materiality as a consideration. It's as a kind of benchmark. It might be worse than, or nearly as bad as.
Yeah, if someone wants to build a particular property, which has disbenefits in certain ways, one of the considerations is, well, if we don't grant planning permission, the property owner could build something else which would have equal disbenefits. So,
I can see how, maybe at a stretch, it could be a useful label for the material consideration that you're urging here. But the point that really matters is, did the inspector properly grapple with it as a material consideration?
Yes, it's a counterfactual. You have to consider counterfactuals, and did the inspector properly consider the relevant counterfactual, or did he consider an irrelevant counterfactual consideration? And the submission, and if you look at I'll take you briefly, I'll give you the references in the interested parties' submissions and evidence. But there's paragraph 4, and I'll give you a list of paragraphs because there's no point, and I'll summarise. Paragraph 4.15 at 95. 4.4.
I didn't catch that reference. I'm so sorry.
Sorry, it's 4.415 at supplemental bundle 95.
Thank you very much.
437 at supplemental 100. 5.7 and 5.8 at 102. 5.7, 5.19 at 104.
So what was the last one?
Sorry, 5.7 and 5.8 at 102.
I've got that.
5.17 to 5.19 at 104. I'm sorry, I'm gabbling.
All right.
And the applicant deals with it in, the appellant now, Mrs. Strack, dealt with it in paragraphs 6 to 10 of the written submissions at 2014 to 214 to 218. And specifically, it's dealt with by the interested party in their written submissions in paragraph 23 at 243 and paragraph 43B and C at 249.
Right.
Now, and the point is, we have, whatever went on in the past, from 2018, we as landowners have prevented the recreators or anyone from carrying out any work of maintenance on the land, cutting back brambles or doing anything. Therefore, as a result of that, we are not compelled to allow them to do that. As a result of that, the ecological benefit or the ecological standard of the land has degraded, and that will continue if you don't grant this application, because we're going to continue to prevent people going on the land to clear it or carry out works to it as was done prior to 18. It's a deeply unattractive position, and we say it's one that's wrong as a matter of law. And we say it's wrong as a matter of law for two reasons. First of all, we say that it's inherent in the right of recreation over a TGV, as it is over with any right, such as an easement, that the recreators, those with the benefit of the right, are entitled to carry out works to facilitate the exercise of that right. And we quote Lord Hoffman at 356 to 357 in the Sunningwell case. I'll take you to that. It's Divider 17 of the Authorities Bundle. Sorry, it's 347 to 348.
Sorry, which tab was it?
I'm sorry, it's tab 17.
17.
And it starts, the passage starts at 347 letter H. The main purpose of the Act now is to preserve and improve common land and town and village greens, the effect of the force of the Royal Commission, land 55-58, Land 462, which emphasised the public importance of such open spaces. Some commons and greens were in danger of being encroached upon by developers because of legal and factual uncertainties about their status. Others were well established as commons or greens, but there was uncertainty about who owned the soil. This made it difficult for the local people to make improvements, for example, by building a cricket pavilion. There was no one from whom they could obtain the necessary consent. And if you look at various other cases, it's quite clear that in customary rights over a TVG or the statutory rights, there is a right, an inherent right to go on and make the land fit for what you're doing. If you look at White and Taylor, which is paragraph, which is divided 45, Mount and Ismay, divided 13, Lancashire and Hunt.
Mountain is May, sorry.
Is divider 13.
I'm just making a note of it. And the third case?
It is Lancashire and Hunt.
Yeah.
Mount and Ismay was the ability to hold a horse race on one day in a year.
Yeah.
Fitch and Rawling is cricket.
Yeah.
And there's horse training. The point is that, for example, if it's clearly recognised that a right of recreation, a sports and pastime, is cricket. Now, in order to play cricket, you have to have a relatively flat pitch, so it must be inherent in the right of playing cricket to be able to go on and cut the grass.
Cut and roll the
And in respect of dog walking, even if it's dog walking, there must be a right to go on and clear the paths or clear the land to make it fit for walking. And one sees from the inspector's report that the land was overgrown. It was difficult to get way through the paths. Now, in my submission, it's clearly inherent in the right of recreation that you've got a right to go on and make it fit for that. There's one other point I have to return, much to my chagrin, to TWL, TW Districts at divider 23, because there is a relevant point. It's at paragraphs, it's divider 23.
Yeah, just a second. You would? Please? Yeah. Thank you.
Paragraphs 65 to 68.
Yes.
And the point in that case was, the point was made against the registration that if as the registration authority and the applicant said, in order to work out, the recreators had to accommodate themselves round the activities of the landowner,
yeah,
i.e. the golfers in Redcar and the lorries in TWL, how would anyone in future know what the recreators would be able to do? Because you'd have to go back and look at not what the recreators were doing in the 20-year period, but what the property owner was doing. And suppose, for example, the property owner, I'm not really arguing the case, wants to increase the frequency of the lorries going across it. How would one know whether that was Now, that argument was dismissed by this court and indeed the Supreme Court, and this is what they said at 65 to 68.
Yeah.
But the key is this: what the recreators can do on the land very much depends upon what the landowner was doing during the period of registration. If, as in Redcar, the landowner was allowing golfers, then whatever the recreators had to do, they had to accommodate themselves around the golfers. If, as in TWL, the landlord was driving HGVs across it every 5 minutes, Monday to Friday, then the ambit of the recreator's rights was limited by that.
Yeah.
Here, the landlord is doing nothing on the land. There's no evidence. In fact, the landlord is doing nothing and deliberately doing nothing on or to the land, which in my submission would tend to indicate that the rights of the recreators are not enhanced, but it gives them a wider ambit of rights because they're not interfering with any activity by the landowner during the 20-year period. So, for example, if the recreators said, well, I want to create a new path, I want to chop down these brambles, they'd be able to do that because you're not interfering, you're recreating, you're making the land fit for your recreational rights, and you're not interfering with anything the landowner was doing on the land. It's not as if the landowner is playing golf on the land or have a boating lake on the land or anything like that.
Would it be analogous, at least, with the give and take concept? But where a landowner says, no, you're not permitted to do that anymore, then those who have been doing it have a choice. They either carry on doing it in defiance of the withdrawal of permission, or they desist. Here it seems largely, if not completely, they just stop doing it. But that degree of tension, if you will, between the landowner's activity or prevention of activity and the rebalancing, if you like, of that, his position against the recreator's rights or recreator's activities. Isn't that really analogous to this?
Well, it's not. The point I'm making here is that insofar as one's dealing with what is inherent in the right of recreation, it depends upon what the property owner was doing on the land.
Yeah.
And the point I'm making is that there is inherent in, ancillary to the right of recreation, a right to make the land fit for that right of recreation.
Yes.
The right of recreation is limited by what the landlord is doing or the property owner is doing, but here they're doing nothing.
Yes, but your submission here, I think, on ground 3 really does depend on the proposition, which may or may not have been decided by the inspector. The proposition that this was either a right in itself, or at least facilitative of the exercise of a right. That's your
Yes.
You have to get to that
Yes.
place, don't you, before you can go on and make the submission that he didn't properly grapple with the so-called fallback.
That's right. Well, I mean, let's look at what he said.
Yeah.
If one goes to the... It starts with paragraph 19. Again, we've looked at this before. And deals with paragraph 19.
Yeah.
And then 20 deals with withdrawal. And 21, it's clear that residents and neighbourhood greatly value the village green. And then he details his impression from his inspection of paragraph 22, it's the North Line part. It's largely overgrown and difficult to access with the exception of one well-trodden footpath. Extremely wet underfoot, footpaths wet, slippery, and rises. So it's not in a particularly good state, and that was a point was made by the interested party in those submissions. And what the interested party is saying, well, it's degrading from an ecological point of view, because open brackets, because we're not allowing anything to be done to it, and therefore you could take that into account. The replacement land, because we're going to allow it, is going to be much more ecologically important because we're going to allow works on it. And then if you go to paragraph 30, now he deals with it under the heading public interest, nature conservation.
Yeah.
And that's a recital of section 16.8a.
Yeah.
And paragraph 30 is common ground between the parties. The nature conservation value of the reef lands already degraded to some extent by the spread of brambles, nettles and scrub as a result of maintenance work having been curtailed in 2018. And that's the point made by the interested party. It can be expected this process will continue unless active maintenance is resumed. So he gets the point. The applicants have indicated they have no intention of renewing the permission for the local community to carry out maintenance work on site. Again, I break off deeply unattractive proposition. It's suggested on behalf of the objectors that there might not be a need for some sort of such work to be permitted, as it could be construed as a lawful sport or pastime appropriate to Village Green. This suggestion is disputed by the applicants. It appears to be the case that to date, little work has been carried out since the withdrawal permission 2018. Now, if permissions withdrawn, it's stopped. The choices of the recreators are either to persist and be forcibly ejected, or to take proceedings, or not to do anything at all. And it's not an attractive proposition to say, well, you haven't done it because you haven't taken proceedings. And then it's paragraph 36.
Well, this is the landowner. That is to say, the owner of the freehold interest in the land.
That's right, the interested party.
Who has thus a property interest.
Yes.
Saying no more activity of this kind on my land.
Yes.
Please.
Yes.
Why is it a deeply unattractive proposition?
Well, because it's now used to say, well, the replacement land, this is ecologically degraded land, and the new land, we won't be. And we're going to set up a committee. We're going to allow the replacement land to be maintained in such a way that it won't be, and therefore it's advantageous from an ecological point of view to replace the release land with the replacement land.
Let's leave that to one side for the moment. Just focusing on what Ms. Strack and other objectors were saying. They were asserting a right here. And can you, as I understood the case that was being put, that they were saying that this was actually a right, not merely facilitative to the exercise of the right.
Well,
but the act, all right. But
they've said it's a right, but they've also said, as I go on to my secondary submission, that it is in fact, if it's not ancillary to a recognised right such as dog walking, the right to maintain land ecologically, as in gardening, it should be recognised quite separately as sport.
I just wanted to get at what the right was that was being asserted. The right to maintain land ecologically.
Yeah, I'm putting it twofold. I'm putting it either as an implied right to the right to exercise, i.e. walk dogs, and to clear the land to enable that to occur.
Yeah, and the right to maintain land ecologically is a pastime.
Yes, I would say that we would submit that is a properly now to be regarded as a pastime separately. Dog walking wasn't regarded as a pastime or sport in the 18th and 19th century. No. It's now the classic recreational activity.
Right, so right to maintain land ecologically a pastime, the clearance of brambles and cutting of vegetation and so forth may be activities facilitative of that right. Is that it?
Yeah, it's either activities facilitative of the right to recreate a proper, a well-recognised right, such as walking your dog or exercising, or it's a specific right, that is, for example, a right to clear to make sure ecologically sensitive plants, or right to erect bird boxes or something like that.
Well, in a different case, it could be, I suppose it could be a wildflower meadow, which to retain its biodiversity has to be cut or have sheep grazing on it at a particular time of the year. So that you get the widest variety of plants.
Yes. If gardening is a sport or pastime on your own land, we would submit it should be recognised. If we have to go that far, it should be recognised as a properly. This forms the cross appeal.
And then the submission is that, as a matter of law, they couldn't withdraw permission for your exercise of that.
That's right. And whether it's one or the other, and if you look then at paragraphs 36, 38 and 39 of the inspector's report, he sets out the argument, but doesn't grapple with it.
Right. The other side says, I think, that it's clear from these paragraphs that he had it well in mind what was being said, and he discounted the possibility of it being resumed.
Well, there's no factual basis for that, because Mrs. Strack and her co-objectors had said they were willing to do it, and if as a matter of law he's saying, well, as a matter of law they don't have a right to, then he's wrong on that. That's the point.
Right.
But, I mean, paragraph 13(8) is a strange submission, because remember, this is under a strange point, public interest, nature conservation. Paragraph 38 is nature conservation is only one of the several factors that should be taken into account. That's right if he's dealing with section 16(6)(c) and 8(a). That is, it's the public interest. Although the opportunity for enjoyment and study of nature is an important public benefit that exists in the British screen, it's not one that should exclude provision of opportunities for other lawful sports pastimes to be enjoyed. Well, he hasn't got the submission, he hasn't got the point there at all. We are saying this is a right to be considered under section 16(6)(a). That is, it's part of our right of recreation. And he's misconceived and misconstrued what the submission was. And in concluding that, it's unlikely that the release land will be improved, he's either coming to a factual conclusion which there wasn't evidence for, or he's, as we suspect, misconceiving the law in simply saying, well, I'm entitled to take nature conservation into account under the public interest in section 16(8)(a), but failing to consider it under section 16(6)(a). My Lord, I'm conscious of time. I would draw your attention specifically on the latter point.
Just pausing. It's nearly 1:05.
I was about to sit down.
You're nearly at an end.
Yes, I am.
Well, we'll continue to.
Yeah. The last thing I was going to do was draw your attention on the last point as to what can encompass a sports and pastime to the judgment of Lord Hoffman in the Sunningdale case. Page 356 to 357, at divider 17.
Thank you.
And he points out that it's not set in stone what was regarded in the 17th, 18th, 19th century as a sports and pastime is different now.
Yeah.
That's, I think, all I need to say. Can I formally reserve the fact that I deserve? But otherwise, I think I've finished, and I apologise for going.
No, that's fine. You've come very close indeed to what you indicated at the outset. So thank you very much. If you have anything else to add, of course, you'll have the opportunity after the short agenda. We'll start again at 2:05. Thank you.